At 4 o'clock, we're hearing from an attorney for a Georgia death row inmate. The U.S. Supreme Court granted Keith Tharp a temporary stay of execution last night, just hours before he was scheduled to die. The attorney told Channel 2's Audrey Washington the sentence was tainted by one juror's racial bias.
This is information the jury should have had in determining whether the client lives or dies.
Even criminal defense attorney Brian Kammer thought it would be a tough fight for his 59-year-old client, Keith Leroy Tharp.
We are one of the top executing states in the nation.
After sitting on death row since 1991, on Tuesday, more than 3 hours after he was scheduled to be put to death, the U.S. Supreme Court granted Tharp a temporary stay of execution.
We have occasionally, very rarely, gotten stays from other courts, but from the Supreme Court, it's extremely rare.
Tharp was originally charged with the murder of his wife's sister-in-law, Jacqueline Freeman, in Macon. Kammer says within 3 months, his client was tried, convicted, and sentenced to death.
His attorneys did virtually nothing to prepare for the case or investigate Mr. Tharp's background.
After years of research and investigating, Kammer, the director of the Georgia Resource Center, argued that his client's death sentence was poisoned by one juror's racial bias towards African Americans and Tharp himself.
Those views directly impacted his decision regarding sentencing. And that's impermissible in our system of laws. Everyone has the right to a fair and impartial jury.
Right now, Tharp remains in prison. As for what happens next,
my understanding is that the court is going to take its time, essentially, to decide whether to grant full review of this issue. And we'll just have to see what happens.
Kammer says next a conference date will be set to discuss the petition and to decide whether to grant review. He says that process could take weeks, maybe even months. In Northeast Atlanta, Audrey Washington, Channel 2 Action News.